Good afternoon. On behalf of IP North Region, I would like to extend my warm welcome to all of you for today's webinar. This is 59th webinar covering the webinar theme Key Updates and Intersection in Insolvency Law Important Topics. The important topics are latest amendment in liquidation and CIRP regulations and interplay between IBC and PMLA. We are truly honored to have a distinguished speaker, CAPT Joy and Mrs. Harmeet Kaur. Your presence today really adds immense value to the session. As you are aware, that IP North is hosting 59th webinar of IP Network. There is a series of webinars organized by periodically under the umbrella of IPNet, the National Network of Insolvency Professionals. It's my pleasure to have with us IP Parag Singhal, this General Secretary of IPNet. I just give the speaker to him. Kindly comes with the welcome address. Parag sir, kindly.
Thank you, Babita ji. Friends, good evening to all of you. I'm delighted to welcome you all in this first webinar. I'm calling it first webinar of IPNet immediately after the IBC Conclave 2025, which was successfully organized by IPNet on 1st of November 2025 at India Habitat Center, New Delhi. We are privileged to have among us our esteemed speakers, Harmeet Kaur ji and Ms. PT Joy, both members of IPNet. Each of these speakers will be taking a very interesting and relevant topic for discussion. Special thanks to Dr. Ashish Makhija sir, President of IPNet, and our own IP, Sandeep Chitkara ji, Regional Head IPNet North. Friends, though Mr. Chitkara is not here, but I really thank him for the selection of topics and as well as Mr. Makhija for the visionary leadership in shaping this platform. The membership link is available in the chat and we look forward to having more members with us, though our membership has already crossed 1,000 members. Friends, IPNet has become a vibrant community for insolvency professionals across India, fostering continuous learning, networking, collaboration, and not only professional growth, but also growth of insolvency profession. We are committed to supporting IPs through expert-led learning initiatives like webinars and study groups, practical guidance on IBC-related challenges, and a dedicated member portal offering comprehensive resources. For those who are already part of IPNet, thank you for your support. For others, I encourage you to join this dynamic network. Membership details are available in the chat. Thank you for being here. Let's make this session insightful and rewarding. Babita ji, please carry on.
Yes, sir. Now, I request Namrata, please have run the video of IPNet Vision, Mission and Nationwide Network for...
Okay, I'll run that.
Yes, sir.
Deserves a voice, a community, and a platform to grow. Building a united, progressive community of insolvency professionals, driving excellence across India. Every week, every topic, every insight, together. Led regionally, united nationally, ensuring every voice is heard. Together, we shape the future of the insolvency profession. Your personalized space for learning, networking, and growth. Free for every member. Be part of the mission. Be part of the revolution. Be part of IPNet.
Um, Now I introduce my first speaker, who is a member of IPNet, Mrs. Harmeet Kaur. Harmeet Kaur is a seasoned professional with over 2 decades of experience in corporate secretarial, legal and financial domain, particularly in sugar and green energy sectors global. She is practicing company secretary, insolvency professional, and independent director, and a certified post trainer since 2017. Ms. Kaur has actively involved in IBC mandates, advising stakeholders, resolution applicant, committee of creditors, leading assignment in insolvency professional and alumna of SRCC, Shri Ram College of Commerce. Ms. Kaur holds postgraduate diploma in business administration and computer application. She has expertise also in consulting and training in corporate laws and making her valued and serious professional. Now I request Namrata ji for a deliberation and invite the Miss Harmeet Kaur, and deliberation on topic latest amendment in CIRP and liquidation regulations. Hello, please Namrata.
Thank you so much, Babita ji. It's my pleasure to invite Harmeet Kaur for this session on the amendments of liquidation and CIRP. Just a few updates for all our participants. Kindly put your questions in the chat box, or you can raise your hands. We don't want to interrupt Harmeet Kaur with her presentation. As and when feasible, we'll take the question and answers as well. Harmeet, the stage is all yours.
Thank you so much. Thank you, Babita ji. Thank you, Parag ji. And thank you, Namrata ji. Thank you so much. After such a high energy and highly vibrant event of ours, I'm not sure whether I'll be able to do justice to this program, but yes. Let's start with the same level of energy, because we have had two very recent amendments this week itself. So I'm sure all of us would be interested in knowing about them. I have also collected some of the recent amendments from CRP regulations and the liquidation regulations during this year, starting January. Why we chose this subject, let me just give 1 minute about that, because while we are studying so much every day, proposed amendments in the IBC and the existing amendments which are already implemented, so there is a confusion amongst all of us, including myself. I also found it difficult sometimes seeing whether this was in proposed or this has been implemented. So this is just a refresher for all of us to know that this has been implemented. This is not in the proposed IBC, which is still awaited for the winter session of Parliament. So let's concentrate on what is already there, applicable on us. Regulations are have been announced from time to time. CRP regulations have been amended 6 times during this year. Liquidation regulations twice, and some changes we might miss if you don't pay heed to, because they are sometimes so minor that at the time of our process, while we are running through the process, we generally tend to omit the recent ones. So it's a refresher course for all of us. Let's quickly see what is there by the IBBI for us in this year. So it starts with the list of all of them. Here I have missed one circular of 6th November, which I'll be taking up very shortly here. So that is the discussion, not the circular, that is still in the discussion paper. And they have found it relevant because as we are all aware about the 32A, let us understand what 32A was and what it wanted to, implement. So I have only taken up two subsections of 32A. If anybody would like to read along, you can just read along, because some things are important in this section, and that is where this amendment would affect us the most. So they say that it is a very strong section, of course, like section 14, section 238, and third is the 32A. I always consider these three to be the most powerful sections of IBC. So 32A starts with a non-obstante one. It says, notwithstanding anything to the contrary contained in this code or any other law for the time being in force. So such a power. the liability of a CD for an offense committed prior to the commencement of CRP. We are all aware that it started with Ghanshyam Mishra case, and clean slate principle was laid down at that time. And not only after 32A, but prior to that also, the concept, the rationale was being misused, and it is still prone to being misused. Why? Because once a CD understands, once some promoters who are having such liabilities because of penal liabilities, because of non-compliances, or maybe mounting penalties on the assessed and ascertained tax liabilities, etc., they would definitely want to take advantage of this 32A, and they are taking advantage of this section. So, how to curb, how to understand, how to stop? Because the optics are correct, the debt is there, the CIRP is initiated on the basis of the facts in front of you, and you can't just say that CIRP was faulted or initiation of it was, with some malified intent or something, because the debt is there once it is proved. So it has to be accepted, it has to be admitted into the entire CIRP process. And therefore, that is where the erstwhile promoters would get benefited out of the section 32A particularly. So why this section has been, why this discussion paper has been brought in? Because they actually wish to see who is the buyer now. So I'll go back to 6th November dated discussion paper, but let's just see what it actually said. If the resolution, so prior period defaults and offenses shall cease to have effect on the CD once the plan is approved. And for those PRAs, for the new management, which was not a promoter or in management or control of the CD or a related party of such person, then such person would get benefit out of this 32A, and they shall get the clean slate. Or a person with regard to whom a relevant investigating authority has reason to believe that he had abetted or conspired for the commission of the offense and has submitted or filed a report or a complaint to the relevant authority. So these people won't get benefited out of 32A. And the purpose of introducing this section was to give benefit, to give clean slate to the new owners. Now let us see, we are all aware what is happening around. And the purpose behind this discussion paper is to find out who is the ultimate beneficiary of the PRA. Let's see how they have worded it. They say that it aims to enhance transparency and integrity in the CIRP. It focuses on Section 32A, which grants immunity to the CD and its assets from prior offenses if the management or the control now genuinely changes after the new PRA has come in. To standardize the disclosures, right? So it was up to the RP how he used to take the disclosures from the RA, how he used to conduct the due diligence on the RA, whether 29A or a related party. Section 29A subclause J is such a huge subsection. One cannot just complete the due diligence under 29A J. If you read that very carefully, it is such a vast study, it's such a vast area of research, and we generally are not doing justice to that subsection. So to standardize the disclosure practices and to reach to the ultimate owner, the ultimate natural person who is owning or controlling that PRA or SRA, this amendment is being introduced. But this is again not yet introduced, not yet implemented, it is still in the discussion. There is an affidavit which shall be called 32A affidavit, that shall be a declaration of eligibility to claim immunity under section 32A. So comments on this are invited until 16th November. You can go to IBBI portal, and that is readily there. You can just give your comments on that. Comments are to be given on two affidavits. One is Annexure A and a second is Annexure B. The Annexure A talks about statement of beneficial ownership. We are all aware about the concept of ultimate beneficiary, significant beneficial owner, SBO concept that is already there in FEMA and in the RBI and in the SEBI regulations. So we are aware about the concepts, but they were not harmonized in the IBC. And it was the RP or the agencies that RP used to appoint. It was up to them to find out who was the ultimate natural owner of the SRA. And generally, as I told you, it's such a vast area. You cannot just reach to the ultimate owner unless those disclosures or organization charts are provided by the RA itself. So, what does the Annexure A talk about? It says based on the RBI's KYC master direction, which has been amended on 16th of August 2025 itself, and the definition of beneficial ownership has been amended very recently in August, as I told you. It requires the PRAs to disclose all natural persons who are having ultimate ownership or control on the SRA. The thresholds have been set as the companies or LLPs, whosoever is holding more than 10% ownership or control, the trusts, the author, trustee, or beneficiary for more than or equal to 10% of interest, unincorporated entities, more than 15% ownership or entitlement. Exemptions are also provided where PRA or the controlling entity is listed in India or notified foreign jurisdictions. Why? Because SEBI itself, SEBI regulations themselves talk about SBO declarations, and those declarations are already filed with these stock exchanges. So those exemptions are given to the listed entities. If you are a subsidiary of a listed entity, even then that exemption is applicable to you. If you are yourself, if the SRA is itself a listed entity, even then this exemption is applicable. So the detailed shareholder data is not required as required in the Part A, and uh, only when that is already available on a stock exchange in India or an outside jurisdiction that has been notified through this annexure. The format has part 1, that is a basic PRA details. Part 2, disclosure for listed entities. That is a very short disclosure that they have to only provide the link at which such disclosures are given on the stock exchange website. So one can directly go to that link and get through the entire detail over there. Third is the ownership structure and beneficial owner details. This is applicable to those who are not listed. So this is a detailed part 3. This is a detailed table talking about entire ownership structure, and they are also providing you some opportunity to provide your organization data, organization chart, the entire structure in a maybe a flowchart format or a diagram, if you wish to attach that. Then a declaration on completeness accuracy, that is the annexure B. So what does annexure B talk about? It says that the PRA or the SRA, their authorized signatory shall sign this, stating this to be true and correct to the best of his knowledge. And the eligibility under Section 32A immunity, the name of the management which is disqualified, none of the new management is disqualified. It is submitted under relevant CIRP regulation. The CIRP regulation shall be added to this effect. And further, that any false declarations, we are aware that we shall be penalized for that. So objective is, as I told you, to enhance transparency, consistency, due diligence, identifying the true beneficial owners of the PRA, preventing the misuse of the clean slate immunity, and aligning and harmonizing the insolvency regulations with the RBI KYC norms and SEBI disclosure standards. So this is the recent one, but this is still on a discussion stage. A discussion paper has been introduced, and this shall soon be a reality for us. Now, let's see what is already there. So the most recent and hot one has been the PMLA wala undertaking. Everyone is talking about that. Let us also discuss something about that. So that was issued by IBPI by way of a circular dated 4th November. And already some of the IPs were getting these reliefs from the special courts by informing them properly about the CIRP being going on and the assets not to be covered by ED, or at some stages even NCLAT have given such orders, but in some cases such reliefs have also been granted by the special courts. Here, after this latest circular which talks about the assets which are under CIRP or under liquidation, and in case they are attached by the ED also. This has now been established that this has been issued, of course, this has been issued after consultation with the authorities, applicable authorities under the PMLA Act also. So we are now very sure that the assets which would form part of the liquidation estate or maybe the part of the resolution plan, very important and intricate assets having value under the CIRP for the CD, for the PRA or the SRA. So now they are out of the hinges of the ED. Even if they were attached prior to the CIRP period, now you can give a special undertaking, which has been proposed through this circular, and the format is also given. Now, the assets of the CD which are attached by the ED under the PMLA, now IP can file an application before the special court under section 8 subsection 7 or 8 subsection 8 of the PMLA for restitution of such assets. Now they shall come back to the either to the CD for the SRA or to the liquidation estate, as the case may be. So this has been introduced to facilitate faster freeing of assets struck in PMLA matters. The IBBI, in consultation with the ED, has formulated a standard undertaking. IPs must furnish this undertaking along with their application to the special court. So we have just talked about section 8 subsection 7 or 8 subsection 8 of the PMLA. Is anyone aware about those sections? Would you like me to just read through, or somebody would like to tell about those sections? Let's hear from the people who have recently read PMLA. If anybody would like to say something about it.
Harmeet ji, we have next session for PMLA.
PMLA only?
Yeah.
All right.
We'll
Okay.
discuss in that.
Okay, so let me just quickly touch through the recent sections because they have a bearing on what we are going to talk next. So 8 subsection 7 talks about where the trial under this act cannot be conducted by reason of death of the accused or the accused being declared a proclaimed offender or for any other reason or having commenced but could not be concluded. The special court shall, so these are the circumstances under which special court shall, on an application moved by the director or a person claiming to be entitled to the possession of a property in respect of which an order has been passed under subsection 3. So this 7 would come into play where 8 subsection 3 order has been passed, that is for attachment, and 8 subsection 8 shall come into play when the confiscation under 8 subsection 5 has happened. So these two both talk about restitution to the beneficial owner, right? Sorry, Sunil ji, आप थोड़ा mute करिए. So 8 subsection 3 and 8 subsection 5, again, these are important now. 8 subsection 3 talks about the attachment by the AAA, and 8 subsection 5 is the confiscation by the central government. So under both these sections, respectively, 8 subsection 7 and 8 shall apply, and in any of them, this undertaking shall be given. So what is the undertaking? It is applicable only in the cases where promoter is ineligible under 29A. So the restituted assets shall not be sold, transferred, or otherwise disposed of directly or indirectly to any person covered under 32A to 1 or 2 of the IBC. The restituted assets shall not be utilized directly or indirectly in any manner that benefits any person or entity named as an accused or charge sheeted under ECIR by the Enforcement Directorate or relevant predicate agency on the basis of which ED has initiated proceedings. So here those sections are covered, those people or persons are covered on which this shall not be applicable. The restitution shall not take place. Now, hereafter, IP is continuing giving that undertaking. IP is saying that from the date of restitution until the approval of the plan or the dissolution order, as the case may be, I shall submit quarterly status reports to this honorable court containing status of the assets, details of their usage or monetization, list of beneficiaries to whom this has been distributed, or any information on any sale or transfer of such property. Disclosures in the insolvency process. I have disclosed in the IM or the auction notice the details of all the properties under ED attachment as on the date of this submission. If any further details become available subsequently, I shall disclose them in the updated versions of the IM or the auction notices. So these are the disclosures that the IP shall give, and he is giving an undertaking today to the special court. I will extend full cooperation to the ED during investigation, as if we have a choice, providing details of buffet transactions, COC, its constitution, percentage of voting shares, and providing details of the SRA or the bidder, including a copy of the application and relevant orders. Fifth and sixth points are undertaking to provide documents as and when they are requiring, and duration shall be until the approval of the plan or till the dissolution order. So this has been the latest undertaking which shall be attached to the application to be given to the special court. So that was about the recent circulars and discussion paper. Now we are starting to talk about the CIRP regulations and its amendments. The first amendment during this year came on 3rd February. I think the font is very small. I'll just take you through the important ones from out of this. There was a concept introduced as a facilitator in the class of creditor cases in the CIRP where the number of creditors in a class exceeds 1,000. The committee may direct the IRP or RP to appoint an IP other than the IRP, RP, or the AR as facilitator for the subclass within the creditors. Right? So the role and responsibility of such facilitator shall be to facilitate communication between AR and the creditors, to attend the meetings of the committee, to provide information and clarification to the creditors in the subclass or any of the task assigned by the COC. That was introduced to improve representation and communication because the number of people, the number of stakeholders in that class, the creditors were more than 1,000 or are more than 1,000. So that was the first amendment of February. It also talked about a lot of changes were made in February regarding the real estate matters. Where the CD has any real estate project, the committee may direct the RP to invite competent authority as defined in subsection 2, section 2, subsection P of RERA related to such project to attend such meetings. And the committee may decide without voting rights for providing inputs on the matters associated with the development of the project. Report on the status of development rights and permission of real estate project. Where the CD has any real estate project, the RP shall prepare a report detailing the status of development rights and permissions, submit that report to the COC, and submit to the AA the report referred to in A along with comments of the committee on or before 60th day from the insolvency commencement date. So whether NCLAT has stayed the CIRP, whether the NCLAT has allowed the promoters to carry out the project, further development, etc., or not. Now, RP has a specified role in the reporting structure under the real estate matters. In the same February amendment, the EOI talked about the Form G. The Form G was having one more column, that was the declaration of MSME. Whether the CD is MSME, if yes, then the registration number was to be provided in Form G. And the mistake happened for 2-3 months. People were not aware and they did not pay any heed that this small amendment has been made in Form G. And the publishers, they used to just send the same Form G and they were just using the same format. So this was a minor amendment, but it caused a huge problem for certain RPs, I'm aware, even after the publishing. Provided that where the CD has any real estate project, the committee for an association or group of allottees in such a way representing not less than 10%. So I'm sorry if there is some background noise with me. So here it was also allowed to give some relaxation in the eligibility criteria for EOIs and the conditions relating to refundable deposit. The same was also introduced in the RFRP. So if you are in a real estate project, the committee may relax the requirements to provide the performance security for the association or group of allottees if they want to come as the PRA. Another change was the monitoring committee, which was already there practically. It was only introduced in the regulations at this stage. The monitoring committee, RP, could be the chairman of the monitoring committee, who all shall be there, the disclosure requirements, the quarterly reports, that was fixated hereafter. Earlier, monitoring committee was only a product of the resolution plan, and it was not there in the in the regulations or code, of course. So 3rd April, I think I have missed this slide. 3rd April, only one change was made, and that was in the Form H format. The Form H was changed to take into effect the MSME status and certain minor changes, which were the reflection of 3rd February changes only. 19th May amendments were also very minor, but they were the pathway to the 26th May amendments, basically. So 26th May also had major amendments to the CIRP regulations, just like 3rd February amendments. So the 4th amendments, these were talking about the part-wise, project-wise resolution. So RP may invite EOIs for whole or part of the assets, including concurrent invitation to preserve value. So it has to be decided when, at the time you are taking up the item of approval of your Form G timeline, CRP timelines, at that very initial stage, maybe the second or the third meeting itself, rather second meeting, COC meeting itself, you have to take care, you have to take approval of the COC, whether they would like to sell the company as a whole or in the assets in part. In case that is more commercially more viable, so COC may take a call there and then, and accordingly the Form G shall be published for the sale of the company as a whole or in part. So 36A 1A was introduced. The RP may, with the approval of committee, invite EOI for submission of resolution plan for CD as a whole or sale of one or more assets. Then staged payments. It was very important because there were litigations all around for this subject. Proviso to 38(1) was introduced, which said that where a resolution plan provides for payment in stages, the FCs who did not vote in favor of the plan shall be paid at least pro rata and in priority over the FCs who voted in favor of the plan in each stage. Regulation 18 sub-regulation 5 was introduced for interim finance providers. They can be invited to the COC meetings as observers, but they shall not be having any voting rights. Regulation 39 sub-regulation 2 was introduced, stating that all the plans, including the non-compliant plans, shall be presented to the COC with relevant details to ensure the transparency. So RP's report shall clearly say which is the non-compliant plan, but all of them shall be presented to the COC. Revised CIRP forms were launched. That was the biggest change of 26th May. They were introduced by way of IBBI circular as well as the amended regulations. Regulation 40B was entirely substituted. 9 forms used to be there earlier, which were consolidated into 5 forms. So this consolidation has actually helped in multiple compliance dates. Our forms used to scatter around the entire month, and we used to just miss it by one day and ended up paying 590 rupees the next day. So it has happened with all of us. So now they have been streamlined and multiple due dates are not there for us. And in order to facilitate 2 months, there were no penalties, and these are now very well established. Although the forms are very comprehensive now, even some people are finding it difficult to fill the forms now, but yes, they have at least brought some peace of mind that initial 10 days and you are through with the monthly reporting system. The 5th amendment was brought in on 4th July, and that talked about information memorandum. 36 subregulation 1 said, subject to subregulation 4, the RP shall submit the IM in electronic form to each member of the committee on or before the 95th day from the ICD date and its subsequent updates thereof. So earlier it was just assumed that he has to update it as and when a material information is discovered, but now it has been part of the regulations itself and you have to update it as and when there is some change in the material information or the contents of the IM. Another sub-regulation HA has been introduced in in the regulation 36 sub-regulation 2. Details of all identified avoidance transactions, if any, or the fraudulent or wrongful trading and subsequent filings before the AA shall also be included in the IM. Another sub-regulation 2A was introduced. It says that a resolution plan shall not provide for assignment of any avoidance transaction where those information were not disclosed in the IM and they were not intimated to all the PRAs before the last date of submission of the plan. So in those cases, the assignment of those avoidance transactions shall not be provided. Any treatment of those avoidance transactions shall not be provided by the PRA unless the information was given to them prior to the last date of submission of the plan. So it is again putting a strict timeline on the RPs to complete the transaction audit on time and provide the complete information to the PRAs, provided that this sub-regulation shall not apply to a resolution plan that has been submitted to the AA prior to 4th July, prior to this amendment. The 6th amendment has been very recently brought in on 14th October. It talks about the sale as a going concern. Rather, it is emanating from the changes made in the liquidation regulations. And this definitely, I think, is a subject of discussion in the liquidation regulations, second amendment dated 14th October. The regulation 31A, which had a reference to the sale as a going concern, and regulation 32, which strictly talks about the sale of a company as a going concern, has been omitted in entirety. 32A was discussing about sale as a going concern. 32 was having two clauses: either the business of the company is sold as a going concern or the company is sold as a going concern. There were a lot of practical issues in the sale of the company or its business as a going concern, because going concern has its meaning coming from the assets as well as liabilities, and the entire system, entire package shall be given to the new buyer or the bidder in the liquidation period. But problem here is that the bidders are only coming to see the assets, and the liabilities were having an impact of when you just assign no value. And you have had challenges in the Income Tax Act also. They were settled with time. And here we have not yet developed a system where the liabilities shall be, how the liabilities shall be settled hereafter, whether the buyer shall avail those benefits under carry forward of those, whether that will be available to them or not. So going concern was creating only a confusion, and this was only to be done exclusively at the first sale. So that was also a challenge. And thereafter, if you get some EOIs, some interest from some potential buyer saying that yes, if you can now allow the company to be sold as a going concern. So liquidator was never able to close the exercise. And once the entire exercise through the market discovery has taken place for the company, and now the company has reached to such stage that its parts are to be sold now, so how and why this going concern shall be successful thereafter? It was only for those people who must have missed the bus, and now they are just thinking that now maybe the value must reduce further. But there were challenges, and there was hardly any success in selling the company as a going concern. So this entire chapter has been, this concept has now been removed, and I think this is the logical change that they have brought in. And similar changes have been, the corresponding consequential changes have been brought in the CIRP regulations also. 39C, the COC at the last meeting had to assess whether the sale as a going concern shall be explored or not. Fee of the liquidator had one point, point B, subsection, subregulation B of 39D, that talked about the period during which the sale as a going concern shall be explored. So that period ka remuneration has also been removed from the CIRP regulation. So it is only a consequential change. Important change is this one, that the sale as a going concern during liquidation period is totally removed as a concept and as an opportunity. So First amendment in the liquidation regulations in this year was brought on 28th January. That was through 47B was introduced, filing of forms was inserted, and LIQ 1 to 4 have been introduced. That is the one major change that has been brought in the liquidation regulations this year. And the second change has been in the mode of sale. Earlier, you have had 7 days for the bidders, for the prospective bidders to carry out the due diligence. Now that 7 days has been omitted from there. A new sub clause 5A has been introduced in Schedule 1 that talks about the mode of sale. And in the auction, the public notice shall state the prospective bidders shall that the prospective bidders shall submit an undertaking. This we were already taking from the bidders. I understand all of us were taking that, and this has now been introduced in the regulations. And second insertion has been 12A that talks about the highest bidder. Within 3 days of declaring the highest bidder, the liquidator shall conduct due diligence and verify the eligibility of the higher bidder himself also. It is not only about the affidavit that shall be submitted by the bidder. It shall be the duty of the IP also, similar to the cases as at the time of plan submission, you do take the 29A affidavit, but you also carry out the due diligence yourself, being the RP. The similar liability has been cast on the liquidator also, that within 3 days of declaring the successful highest bidder, he shall also carry out the 29-acre search. So these were the amendments, and we can discuss any of them now. So I think we are also having Ashish sir today. Um, if we are having him, we can just have him first. If you are waiting for him, we can have some questions. Namrata ji, as you guide.
Thank you so much, Harmeet, for the updates right through 2005. You're almost in the end of 2025. So it's been a really refresher course from you, and I would invite questions. Until then, मेरी सी छोटी सी question ले लीजिए. Regarding this 3 day mandate for liquidation under sale, and then we go to the SEC for consultation. We have to go to the SEC. And if you go for consultation, it's deemed voting. तो वो वोटिंग नहीं करके देते हैं, तो हम हाउ डू वी काउंटर दैट इन आवर मीटिंग? सी वी पुट अप highest bidder is now eligible to be successful bidder, and he has to make the balance payment and everything. And I've had this problem, and I kept the SEC meeting within 3 days and told them आज ही voting करके हमें बता दो. They did not. हमें internal approval.
But my personal view here is I have also conducted 2-3 auctions which have been successfully completed. I have never asked SEC about their voting. I have never sought their vote on highest bidder. Highest bidder has been declared by the system. The auction has taken place online. Now it is BankNet. So you will automatically get the entire thing done, and the sales certificate, etc., is now being automatically generated. So I don't think SEC has a role here. So they won't have and they can't have a different say on the highest bidder. It has been automatically, transparently done through the process, and only liquidator has a right to declare that. You can just intimate them. My practice has been I have only been intimating to all of them that he has been the successful bidder, and the results are here. So results were कोई भी थे, टाइगर ई ऑक्शन और कोई भी किसी पे लिंक स्टार किसी पे भी करते हैं, हम अभी तक करते आए थे ऑक्शंस. They also generate their auto reports, है ना? So you can just share those reports with SEC, and they will never cast their vote on time. No matter how hard you insist, how much you inform them about the procedures that are applicable to you. In the CIRP, we always face this issue, but liquidation, I don't think SCC voting or approval would have much of an importance. As long as the regulations are binding on us, we can go ahead and declare the successful bidder. He has to deposit 25% in within 24 hours, and all those timelines are sacrosanct. What would SCC do?
So far as I know, Harmeet ji, SCC can only advise that to prior to
Yes.
bidding. That to prior to bidding.
Yes. So once the
They have only
auction has
advisory role,
completed
nothing else.
successfully, no one can interfere in that, I
And
think.
that advisory is not binding on liquidator.
Anyways, yes. So you can take advantage of that very clearly written line. There is only one line in the entire IBC plus regulations जो बड़ा relief देती है.
वो यही
पर
है.
ये अमेंडमेंट जब आई थी ना सर, एक्चुअली क्लियरली लिखा है वो स्केड्यूल में, मोड ऑफ ऑक्शन, दैट एससीसी कंसल्टेशन होना जरूरी, मतलब हमने उनको इन्फॉर्म करनी है, ये लो ये 29A की रिपोर्ट ले लो, ये लो भाई बैंक की नेट, बिकॉज इफ यू डोंट रिवर्ट टू बैंक की नेट विद इन 3 days, द अपना डिपॉजिट ईएमडी भी उड़ जाए. So that our timelines are so, like you're saying, sacrosanct. We have to work on those timelines. So we, as a practice, intimate them. We keep also an SEC and inform them क्या हुआ था. We voting नहीं डालते, हम उनकी on record in principle approval ले लेते meeting में.
So there is principally a basic difference, or there is a primary difference between consultation and voting.
Voting, yes. वो 31 है तो very clear है on that.
Yeah. So after the auction is completed, I don't think we need their approval or voting on something. You can just intimate them and comply with the strict timelines of Schedule 1.
So any further questions? We invite questions from the participants. And also, please keep your screens on so we can enjoy the question and answer
There is
session.
a question in the chat box. They say, as per the new format, there has to be a due diligence certificate to be provided by the RP. It has to be from external agencies, right? So this does not mean that the certificate has to be from the external agency. It is your choice. You can get the 29A due diligence done by the outside agencies who are expert in this, but ultimately RP is liable to make his own opinion on the basis of the certificate that he has received from the outside agency. So RP ka certificate shall be mandatory even if you have got that research done by the outsiders. So RP has to apply his mind. You never know, you will be answerable at NCLT level or maybe IBBI level. The form goes to both of them. So your certificate has the value. Outside agency can only support your decision. You can just rely on their findings. Is that okay?
That I think that is suited to that question, perfectly answered. And जब तक मैं एक question पूछ लेती हूँ, audience can please come up with further questions in the chat box or even come online. See, with the non-compliant plans now being presented to the COC, what mechanisms should the COC use to objectively evaluate such plans without deviating from the mandated decision criteria?
So why would COC get into evaluating those non-compliant plans? That is
Proposed वाली amendment आई है ना कि even the
And-
non-compliance ones तो हमें present तो करनी है.
present to करने हैं, but voting shall take place only on the compliant plans, right? So evaluation.
Actually, if COC says, then we have to, as per the commercial wisdom of COC. I understand. Harmeet is the best judge in that matter.
No. We can all have our opinions, ma'am. तभी हम
So
court
in
में
so many
आमने
cases,
सामने
I
खड़े
have
होते
to present non-compliant plan as per the directions of the
हैं.
COC
You
as
have
well.
to present, but non-compliant plans पे, as far as my understanding goes, voting cannot take place. Voting shall take place only on the compliant plans. And if
That's-
COC has a different view, then you have to record that view, because non-compliant plan cannot be approved by the NCLT. They also have only one job in the entire thing, that is 30 subsection 2. Only the compliant plans they can just have a look at.
Very
So how would you take that up to that level? Your job was to check whether they are compliant or not. How can COC approve them? How can they vote on that? So I don't think they can vote on that. They can evaluate that. They may look at it. They may have a have an understanding of what the proposer has proposed. There might be some commercial value in that. They can offer that while they can use that while negotiating with the other PRAs,
Yeah.
but they cannot vote on that. We should not. We should inform them about this
And
at the stage itself.
yeah, very true. That's the key actually, because I think that's the key to the negotiation skills. Because for the non-compliant plans, we just had a seminar with Triple IPIC. Ashley sir only conducted it today, whole day. So same thing that you're saying, very true. We have to give the non-compliant plans. This is if the non-compliant plan for even CRP cost, जो बोलेगा I'll give only 50%, but मैं plan value बढ़ा देता हूँ
Hmm.
to lure the COC. But like you're saying, very true. So that's only for negotiations. Okay, if you can give that much plan value to to the CD.
Mhm.
So it's technically non-compliant, but they have to give the CRP cost. Just negotiation skills.
Yeah.
Okay. Any further questions in chat box? All right. With this, I'd just like to thank Harmeet.
Thank you.
Thank you so much for the wonderful presentation and also taking up the queries and, like I said, giving us entire synopsis of 2025 CIRP and liquidation. And with your elegant submission and elegant presentation, we are really honored to have you with us. Right now, I would request Parag sir if we can transit to the next with PD Joy's sir's presentation.
I'm looking for Mr. Makhija. If he's there, then we need to have a 10 minutes break so far as this webinar is concerned. Break in the sense that we'll be discussing about our experiences in IBC
Yes.
Conclave
We'll start
2025.
with Harmeet sir then. Can we start with Harmeet on? Because I haven't still reached Bombay after Delhi since last Saturday. I'm still, my mind, I'm still there.
Yeah.
Physically.
You're still in
Now,
Delhi.
just a moment. I'm trying to call Mr. Makhija.
So Harmeet, how
Now,
was the
So we
So
can start
I
discussing
have
now. Yes.
to.
can we start with the next session?
Babita ji, we will be taking a 10 minutes break in the sense that we will be discussing about our experiences on IBC Conclave 2025. And meanwhile,
Yeah,
Mr.
yeah.
Ashish Makhija will also be joining us. To begin with, may I invite Harmeet ji to share her experience in the conclave?
So let me just admit that this is the new family that I have got, and we are actually calling it IPNet family now. So all the participants who are not yet members of IPNet, so let me just tell you one thing that I have been at this age and this stage, we are all having association with many of the associations around us. It is now quite fashionable to be associated with some, communities of academic importance or something, but this is of the first of its kind that I don't feel as if there is a pressure of performance or there is something I need to do for some. It is all voluntary. Everyone is contributing from their hearts, and we are all at the recipient ends. I don't know how all of us are recipients. So the experience of IBC Conclave especially was the first of its kind because there nothing of political sort. Nobody was having following any hierarchies or something, and we were all together for the common objective of knowledge sharing. And I don't know how it is different, but yes, in my experience, it has been first of its kind experience, I must say. So thank you
So
very much. Ashish sir is not yet here. I'll write
he is
that
not here,
down.
but we all are under pressure now because he will be watching our recorded program.
Okay. Okay. No, no. I don't think we are under any pressure to perform. We are all doing it.
It's on a lighter note, I'm saying.
And
whilst Ashish sir joins, Parag sir, can we invite Shankar Panikar sir is there? And I
Yeah,
think
sure. Shankar sir, please switch on your video and unmute yourself.
Yeah. Good evening, all. It's such a nice feeling to catch you up. And as I always mention, we always interact through digitally. Now since we have been lucky to see them physically, it was all the more merrier. And for me, the great thing is how can such a meeting of persons who've so much shown way to the development of the IBC. For example, we could see them in a lot of case laws, and we could actually see them how they present their things. So it was a wonderful learning for me. And when I happened to be one of the earliest entrants in this profession way back in 2017, early 2017. So I was closely observing all those giants and seeing them physically and hearing from them absolute knowledge and how it was clinically, executed. Wonderful, too good. And I was discussing how Justice M. Kumar would have felt on those last days of May 2017, how he got a call from Sri Jaitley. So it was wonderful. And above all, as I mentioned, lovely to meet up with all of you. I thought we should have a couple of days more so that more camaraderie could have been developed. And I was rushing back to the airport. I thought I will miss it, but luckily the flight was a bit delayed. Thank you so much, guys. I mean, it was such a wonderful. I never thought that I'll get such a welcome and warm. All of us were warm to each other. And next time, Madam Harmeet, we are going to invite you for small talk on, I mean, a small session on a Porsche also.
Thank you. Thank you so much. That is very close to heart. That subject actually. Thank you, sir.
So nice. Thank you so much. I was here. I had a small. I thought of joining in the early from say 4:30 or 4 onwards, but I was held up in something else. So sorry for being late. So that's the only thing. Thank you.
Thank you.
Thank you so much, sir.
Thank you, Shankar sir, for sharing your memories of IBC conclave, and I'm hopeful that these memories will remain for a longer time.
Absolutely. I'm still there. I mean, I'm still there.
And I
Actually,
request you all to plan for next conclave before these memories fade out.
so let's have a 2-3 days residential one. I think
We
ek
can
din se
have, we
get
can
nahi
have,
bhagega.
we can request Mr. Makija for this, and we can plan accordingly.
Absolutely.
उसको शाम को फ्लाइट नहीं पकड़नी होनी चाहिए.
Yeah, bilkul. And moving forward, I request Swasini to please switch on her mic and video as well and share her experience in IBC conclave. Swasini, if you can. Okay. Namrata, please go ahead with your experience of IBC conclave. Yeah, Swasini is there. Yeah, please.
Yes, sir. Sir, it was a surprise. So I was not prepared. So I'll speak whatever comes out of my heart. So IPNet is very, very close to me. I was a alumni of transition earlier. So when IPNet has started, I think when it started, the roots of it started when all of you have the meeting after resolve. So I couldn't join, and it is doing extremely wonderfully. I'm very happy about the weekly webinars, and especially speaking about the IBC yearly conclave. It was wonderful meeting all of you in person, and we were all feeling like we all know each other from a long time, not that we are all meeting for the first time. And the kind of plenary sessions we had were extremely the the forthcoming, the future IBC, whatever the issues are going to come up, and how practically we should be geared up. So many things are discussed, and the panelists selected were extremely good. And meeting all of you in person I'm very extremely happy and joyful to share this. Thank you.
Thank you, Swasini. Babita ji, please switch on your mic, unmute yourself, and share your experience of IBC in conclave.
After this era of lockdown, I have attended this first physical webinar. That was really a great experience and such a huge community. I have seen so much IPs to meet, and such a great panelists are also there. Program is very good. That even IPNet is very close to me. my first joining, and this webinar is perfectly planned and every clock to clock programs. And I have enjoyed a lot, and I must say that I will certainly come to every webinar conducted by our IPNet. Thank you, Ashish sir, so joining me, Parag sir, and so many people, Namrata, Harmeet I know pehle se, but all the IPs, Tina and all, I met all these people first time physically, and there are so many IPs. The event was wonderful. I enjoyed a lot.
Thank you,
Yes,
Babita ji. Now, Namrata, please go ahead with your experience.
Namrata.
Yes, sir. It was amazing. I mean, like I said, I'm still there, just physically here. I'm still on last Saturday at India Habitat Center. And those memories are going to like stay forever, meticulously planned, executed, the stalwarts and the best of the stalwarts of the industry. And like I think Harmeet said, we were all equals. There was no, I had to be calling anybody or, everybody was just equal. Nobody showed any kind of, one over the other. It was just so humbling to be among such stalwarts. And yes, of course, like Panikar sir said, Kumar sir's session, like nobody, nothing compared to that. The feel, the event, everything, and that touch of grace, it was like icing on the cake. So this is something going to stay with us forever. A lot of our members, I think, are still tired from there. Have not joined it. Sandeep was there. I thought I'll catch him for
Yes,
a nice
Deep
little.
is not here now. I just checked.
So I'm going to ask Parag sir to give his feedback. And sir, if we can then, I think it's 5:05. Should we start with our next session? पहले आप बताइए, how was your experience?
My experience. My experience is that any event which is organized, it all depends on the success of that event depends on the participants. Since you all were there, it made it wonderful. I must say that it was an event of the intellectuals, by the intellectuals, and for the intellectuals. It was a completely sober program with legal luminaries there sharing their experiences. I could sense, I could not, even now I could recollect, there is a sense of pin drop silence when Justice M.M. Kumar was deliberating. It was such a wonderful experience. And my sincere thanks to Rashmi ma'am and Ashish sir for visualizing, conceptualizing, and executing such a wonderful program. Team is always there, and I must not forget, and I'll fail in my duty if I don't remember our own sir, who is the head of the conclave, Uday sir. He is not here, but in his absence, I must congratulate him. I must pay our sincere thanks and gratitude to him for all the hard work that he has done, he has put in organizing such seminars. So this is all my experience. Now we can move forward with Mr. P.T. Joy.
P.T.
Yes,
Yes.
Namrata, please.
Yeah, I just introduce. May I have an introduction
Yeah.
of P.T. Joy, sir? Yeah, our next speaker, CAPT Joy. He's the fellow member of Institute of Chartered Accountant since 1999, law graduate from Karnataka State Law University, and faculty of direct taxes in Ernakulam branch of ICAI. He's also partner of Mrs. P. Parekh and Associates, and this is being a practicing firm having 4 offices in India. He has done so many assignments from m- uh, abroad also, contributed in the various matters of Hindi News Daily, the News Indian Express, Malayalam News Dailies, and ICIS SIRC newsletters. Has spoken in more than 800 seminars, meetings, discussions of professional bodies. He has authored 2 law books also. This is being published by Bharat Law House. One is Handbook of Tax TDS, Tax Deducted Ratios, and Guide of Provision of Benami Property. He is the was also chairman of Ernakulam branch of ICAI and co-opted member of Professional Development Committee of ICAI and has been faculty to the Income Tax Department of India for their officers training program. appointed by CBDT to the Regional Direct Taxes Advisory Committee for the year 2022 and 23. Is a, last but not the least, a qualified insolvency professional from IBBI frequently appears before NCLT and Income Tax Appellate Tribunals and Vice Chairman of Karnataka, presently Chairman of Karnataka Insolvency Professional. And now I request Namrata ji to commence with the session.
So thank you so much, Babita ji. And I would just like to invite Joy sir for helping us deliberate on this latest hot topic of interplay between PMLA and IBC. All participants, please on your videos, questions in chat box or raise your hands. And Joy sir, please take over.
Before Mr. Joy starts, it is not Karnataka Insolvency Professional Forum, it's Kerala Insolvency Professional Forum. And we have tied up with IPNet.
Oh, no.
Over to you, Joy, sir.
Good evening, everyone. It is my pleasure and privilege to be amongst all these AIS professionals. First, I must thank Advocate Shankar Panigar, who spoke to me maybe a couple of weeks back that can you take a session for IPNet professionals. I know the IPNet professionals, when we say it is headed by the Bhishmacharya of IBC, the members of IPNet, maybe they are one notch above the other, the professionals in the other parts of the country as far as IBC it is concerned. But readily I agree because I cannot say no to my dearest friend Advocate Shankar Panikar. Then Mr. Sandeep was there behind me. Then Namrata madam spoke to me. And ultimately, we are here. Let me say, let me make it two presumptions. One, it is before starting with as far as PMLA, as far as IBC it is concerned, you are all better informed than me. That is my first presumption. The second presumption, it is as far as PMLA it is concerned, Prevention of Money Laundering Act it is concerned. Before getting into the serious topic of interface between PMLA and IBC, we may need some level of enlightening or maybe at least a bird's eye view of what PMLA is. Let me start with the PMLA. Madam, can I do the screen sharing?
Just a moment, sir.
Yeah, please.
So I
Team
request-
transition, please make Mr. PT Joy as co-host.
So I had messaged them in the beginning of the conference.
Just a
Or
minute.
you can share your PPT, so we can share it for you.
So if you could,
Madam, it is disabled now.
sir, if you could forward this to me on my WhatsApp, I'll show it.
My God. The other one, it's not possible. You can just select me, make me co-host so that.
Just a minute, sir. Give me a second, sir. They are doing that.
Yeah, please.
So you can now.
Hope it is visible now.
Yes, sir.
I'm not putting in the presentation mode. So in fact, no, somebody asked me why the name laundering, the prevention of money laundering. By name, it indicates washing the dirt or laundering. You know, what is the laundering of the clothes? You know what it is. So by name, it indicates no laundering the or maybe making the tainted money, untainted money, or making the illegal money into the legal system. That is why the name it is laundering. But in fact, it has got a background, a history also. In the early 20th century, there was a gangster in the US. In fact, he initiated the term. There was a gangster by name Capone. He is called Al Capone. He earned a lot of money in US by illegal activities. He was a non-gangster. So this illegal money has to be converted into legal money, has to be converted into lawful money. So he invented at various parts of USA across the country, he installed. I am talking about something that is in the early 20th century. He installed laundry machines in various parts so that any person who wants to use the laundry services can come and insert cash, maybe coins or currencies in the laundry machine, and accordingly the services can be used. So money collected from the laundry business. So he has shown, let us say, instead of let us say $1,000 collected, he has shown, let us say, $100,000 collected. So it is inflated. Accordingly, he converted the illegal money which he earned from the what do you call the illegal activities. The money earned from illegal activities he converted into legal money by way of this laundry business. So it says that one way this particular statute has got the name, it is because of the laundry business that is done by Al Capone in the 20th century. This money laundering, Prevention of Money Laundering Act 2002. This is what the statute, the structure of the statute, the Prevention of Money Laundering Act. So it is notified, though it is called 2002, it is notified only effective from 1/7/2005. It is called PMLA 2002, but it is made effective from 1st July 2005. Then it has got 10 chapters. Altogether, there are 75 sections. Then there are rules. Then there are regulations. The last two parts which I have written in red, it is very, very important for us. Because our understanding it is, anything with respect to PMLA, our understanding it is Directorate of Enforcement. In fact, there are two directorate under the PMLA. One, it is a directorate headed by Director Financial Intelligence Unit India. It is called Director FIU. The other directorate, it is called Directorate of Enforcement. In fact, the Directorate of Enforcement, it is constituted under FEMA, but it is given the powers with respect to confiscation, arrest, punishment, and all this. We used to say that as far as the action part of the PMLA, it is done by Directorate of Enforcement, which is constituted under FEMA. But as far as the story part it is concerned, or maybe the romantic part, the family story part it is concerned under PMLA, it is done by Director FIU. Now, we are all professionals belonging to either company secretary or cost accountants or chartered accountants, excluding advocates. In 2023, there is something that has come into existence called a reporting entity. Chartered accountants, company secretaries, cost accountants, they are all made specific professionals under the PMLA. So if such a professional, chartered accountant, company secretary, CS, if they are undertaking certain activities for and on behalf of the client, they will have to register as a reporting entity. They will have to maintain certain records. It is called maintenance of records rules. And they will have to take registration as a reporting entity under the PMLA. In fact, it is all administered by Director FIU, not Directorate of Enforcement. In fact, Director FIU is comparatively less harmful authority as far as Directorate of Enforcement it is concerned. Directorate of Enforcement whatever that we see in the media or maybe in the newspapers, elsewhere, anywhere, what is happening in the country, it is in and around the Directorate of Enforcement, which is constituted under FEMA. In fact, the Directorate of Enforcement, it is not constituted under PMLA. They are constituted under FEMA, but they are given powers with respect to these aspects. I hope I am clear on this. If you agree, I will move on.
Yes, sir. Please go ahead.
And in PMLA, there is something called PLI. We call it as placement, layering, and integration. Placement is the process of transferring the proceeds from illegal activities into the financial system in a manner not detectable by the governmental authorities. Layering is process of disassociating the illegal money from the source of the crime by creating complex web of financial transactions for concealing its source, trail, and ownership. Integration, it is nothing integrating the illegal money, the tainted money into the regular economic system so that its identity it is lost. So in the PMLA, this is what is called a PLI, placement, layering, and integration. If you want me to explain anything, you say I will explain, but otherwise I will move on. And this definition, it is very simple, but it is very dangerous. The definition of money laundering. See, it starts with whosoever. Whosoever, directly or indirectly. This indirectly is the most dangerous word under PMLA. Any person, whosoever, directly or indirectly, attempts to indulge or knowingly is a party or is actually involved in any process or connected with the proceeds of crime, including its concealment, possession, acquisition, etc., etc. If you look at the definition, directly or indirectly, it is not defined. Indirectly, it is not defined under the PMLA. And any person who is directly or indirectly is attempting to indulge. In fact, you should not have done an activity. You are only attempting to do an activity of money laundering. Now, you are planning to do some kind of a in fact, nothing is conspired, nothing is done physically, nothing is acted upon, but you are planning to act upon. You are planning to do an activity which is a money laundering activity. Even when you are attempting to do an activity which is a money laundering activity, even that attempt can be treated as offense of money laundering. Can I move on?
Yes, sir. Yes, sir.
Then there is something called the proceeds of crime. Proceeds of crime means any property. One second. Means any property derived or obtained directly or indirectly. So this directly and indirectly, it is there everywhere by any person as a result of criminal activity relating to scheduled offense or the value of any such property where such property is taken or held outside the country, then the property equivalent in value within the country or abroad. No, they are talking about a scheduled offense. You should know what is a scheduled offense. I hope this PDF is visible. Is it visible?
Yes, sir. This is it.
This is the BEAR Act, the Prevention of Money Laundering Act. In the Prevention of Money Laundering Act, if you take the BEAR Act, there is something called schedule. I will show you the schedule. At the end of the statute, this is the schedule to the PMLA. And in the schedule, there are offenses listed out under various statutes, various other statutes, not under PMLA. There are various offenses listed out in the schedules to the PMLA. The offenses listed out in the schedules to PMLA are not the offenses under the PMLA, but the offenses under various other statutes. Look at this first schedule. These are offenses under the Indian Penal Code. These offenses, they are called scheduled offense, or we call it as predicated offense. Any offense which is listed out in the schedule to the PMLA is called a scheduled offense. This is part A of the schedule. This is the another schedule, offenses under the Explosives Act, offenses under the Unlawful Activities UAPA, offenses under the Arms Act, offenses under the Wildlife Protection Act. Maybe to remove your monotony, please look at the offenses which are listed out in the schedule, where offenses coming under the Wildlife Protection Act, hunting of wild animals, contravention of prevention of section 17A of this particular act relating to prohibition of picking, uprooting, etc. of specified plants. So when you get money from these activities, these proceeds, they will presume that it is proceeds of crime which is used for money laundering activities. So you can be booked under PMLA, not for as far as this offense it is concerned, there will be punishment as far as this statute it is concerned. But for the same offense, you can be booked under PMLA. And it is moving on, so on and so forth. Offenses under the Immoral Traffic Act, offenses under the Prevention of Corruption Act, offense relating to public servant being bribed. For that, you can be booked under PMLA. Something evasion of duty or prohibition of customs, it is an offense which is listed out in the schedules to the PMLA. It is called a scheduled offense. Now I am coming back to the PPT. So the schedules to the PMLA, unless an offense is mentioned in the schedules to the PMLA, unless the offense is a predicated offense, you cannot be booked under PMLA. So the first question that arises, it is when the enforcement directorate is coming to you, enforcement directorate is coming to your premises. The first question that arises, it is whether you have done an offense which is mentioned in the schedules to the PMLA. Unless the offense is mentioned in the schedule, unless it is a scheduled offense, it is a predicated offense, you cannot be proceeded against under PMLA. Can I move on? Sirs, can I
Yes,
move
sir.
on? Now, there are two sections which are very dangerous under the PMLA, which is widely talked about. One, it is the burden of proof. Burden of proof, it is coming under section 24. So, section 24, it says, in any proceeding, relating to the proceeds of crime under this act, in the case of a person charged with the offense of money laundering under section 3, the authority means the adjudicating authority, or the court means the special court, shall, unless the contrary is proved, presume that such proceeds of crime are involved in money laundering. And in the case of any other person, the authority or court may presume that such proceeds of crime are involved in money laundering. It looks very simple. My dear friends, in any penal law, the basic presumption it is, no, see, there are a lot of A's lawyers. Now, what do you call? There are a lot of lawyers, no, see, participating in this particular webinar. Any law other than the PMLA, the presumption it is till the time you are proved guilty, you are presumed to be innocent. So the burden of proof, it is on the prosecution. Here, section 24, it is a reverse presumption. In case of a person charged with the offense of money laundering under section 3, the authority, the adjudicating authority, or the court, unless the contrary is proved, presume that such proceeds of crime are involved in money laundering. And the burden of proof, it falls on the person who is the accused. This is the most dangerous section, even for the heinous crimes. Under the CRPC, now it is BNSS. Even for heinous crimes, the presumption it is till the time it is proved by the prosecution, you are presumed to be innocent. But here it is on the reverse. This is called the reverse presumption. This is an explanation of that under section 24. In any proceeding relating to the proceeds of crime, the presumption is raised by the authority court against a person charged with the offense of money laundering unless contrary is proved by the accused that such proceeds of crime are involved in money laundering, and in case of any third person, because there it says indirectly, any person whosoever directly or indirectly, and in case of a third person, such authority or court may also presume that such proceeds of crime are involved in money laundering. And this one, 45, offenses to be cognizable and non-bailable. The usual language, notwithstanding anything contained, so and so, so on. So no person accused of an offense under this act shall be released on bail or on his own bond unless the public prosecutor has been given an opportunity to oppose the application for such a release. And where the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offense and that he is not likely to commit any offense, etc., etc. So the two dangerous provisions under the PMLA, one it is 24 and the other one it is 45. Now,
Sir,
let me
sir, here one question to you.
tell me, sir.
Can I?
Yeah, please.
Sir, when presumption is reversible presumption,
Reverse presumption.
Then section 45, how, no, this, before this slide, sir. Previous slide, sir.
24 you are talking about?
Yes, sir. This one, this. Where you said that this bail, slide relating to bail.
$45 or 24?
No, 45, sir.
Offenses to be cognizable and non-bailable.
No, there was a slide wherein it is written that court will give bail only when they are of the opinion that no crime is committed. Presumption is when it is presumed that crime is, unless it is proved, it is presumed that crime is done. So will it be possible for court to take a reverse view?
No, it will be like this. Under section 24, there is a reverse presumption when you are arrested, let us say, when you are arrested.
Yes.
Proceedings are initiated against you. They will presume that they have the right to presume that. 1 second, and there are so many people coming. Okay. See, they have the right to presume that. No, when you are an accused, they have the right to presume that you have committed the offense unless it is proved by you that no, see, you are innocent. So they just presume so that you are arrested and the proceedings are moving. When you are presented before the court or when the adjudicating authority is taking action against you, they all, either the adjudicating authority or the special courts, they all have, let us say, statutorily, they have the right to presume that you are an accused or the crime it is committed by you. Then it is your responsibility. Burden of proof, it is falling on you. It is otherwise. You will have to prove that, let us say, the money that you have earned, it is legal money, it is lawful money, it is from lawful sources. And that money that is used for the activity, it is not illegal money, it is legal money. Or maybe if a property is acquired, transferred, sold out, whatever it is. So basically, you have not committed an offense. Under the scheduled offense list, you have not committed an offense. After committing the offense or through the offense, you have not earned any proceeds. When you earn the proceeds, they will presume that it is proceeds of crime. Basically, you have to prove that you didn't commit any crime. You didn't commit any offense. You didn't earn any money from that offense. You didn't use that money for acquiring any property or asset.
Right, sir. Thank you.
This is something we will, depending upon the time availability, the power to arrest, and so we will discuss later on because this is something very controversial. the director, deputy director, assistant director, or any other officer authorized in this behalf by the central government by general or special order has on the basis of material in his possession reason to believe, the reason for such belief to be recorded in writing, that any person has been guilty of an offense punishable under this act, he may arrest such a person and shall, as soon as may be, inform him the grounds of arrest. Here the important words, it is grounds of arrest. We will discuss it. Please hold on. Depending upon the time availability, we will discuss it. Now, interface between, we are coming to the serious topic of interface between PMLA and IBC. Now, the IBBI on 4th November, they have issued a circular. Now, we all know, maybe you also will be knowing that, no, see, 4th November, they have issued a circular. Am I correct? See, if you interact.
Yes, sir. Yes, sir.
6th November.
The 4th November, sir, I think. Now, I will display the circular. In fact, there are two kinds of attachments under the PMLA. One, it is a provisional attachment, and the other one, it is a permanent attachment. This provisional attachment, it is envisaged under section 5 of the PMLA, where it says, when there is a director or an officer below the rank of director authorized by the director has a reason to believe, because there are a lot of places where they use the wording reason to believe, and the reason for such a belief to be recorded in writing on the basis of material in his possession. These are all, let us say, some words taken from, it can be seen in income tax, maybe in other statutes also, the reason to believe and such reasons to be recorded in writing. So on the basis of material in his possession, if he has a reason to believe that any person is in possession of proceeds of crime, and such proceeds of crime are likely to be concealed, transferred, dealt with in any manner which may result in frustrating any proceedings relating to confiscation of such proceeds of crime under this chapter, he may, by order in writing, provisionally attach such property for a period not exceeding 180 days. Now the question it is, here they are talking about the proceeds of crime. Now the proceeds of crime, by definition, proceeds. When it says proceeds, it can be a property, it can be an immovable property also. When the proceeds is in the form of immovable property, and this immovable property is under CIRP, let us say, at the time of initiating proceedings for provisional attachment, this proceeds is in the form of an immovable property which is owned by a corporate debtor during the CIRP process, let us say. Now the question it is whether they can initiate action under section 5 of the PMLA, whether the enforcement directorate can initiate action under section 5 of the PMLA when there is moratorium under section 14 during the CIRP process. I will move on, but before that, maybe for better interaction, if you can just tell me what is your understanding on this. No, say anything as you want. No, see, then it can be a two-way traffic. Now, after all, it is a webinar. Can you just tell me, no, what is your understanding on this? Shankar sir, please.
I have a different challenge when it comes to PMLA. When it comes to
Please switch on the video. No?
Sorry, I forgot that.
You want to see your handsome face.
Yeah. See what happens here in the typical challenge faced by a resolution professional when it comes to PMLA or attachment by ED. How does the RP comes to know about this, and whether a decision based on, for example, in a couple of cases where I have handled, the RP is not in a position as to he gets a his particular assignment is based on the flow of information from the suspended directors or from the company. Most of the cases, people would have left the company, and he is not in a position to ascertain whether this is a provisional attachment or a the real
permanent attachment.
The procedure followed by the ED is like you have given an opportunity to explain your case and give it in writing. So in my case, in one of the couple of cases where I've handled, RP was not given entire details of because he got the shock of his life when ED has called up this thing. So provisional attachment is something giving an opportunity for the offender or the person to show cause or reason as to what he has to say against the observation of the director. This is what you have shot at me, or what exactly is that you triggered the question?
No, I was just asking, how you encountered a situation where during the CRP, the enforcement directorate has served a notice for provisional attachment.
Yes. And in that case, what has happened was the person, the procedure followed by the department is this. They have given a list of assets, list containing that these are the things. Please please give us a detail as to why this is particular details they've asked. What is that you have to mention on these cases, and a series of queries, and unfortunately my client could not answer it properly well. Yes, it is a natural justice was given, but then they come with a final order later on.
Now, you will conclude it. Now, because of the recent Supreme Court judgment in September and also the issuance of the circular by the IBBA, now it is almost concluded, but still how they have come to that stage, maybe some prelude, some background information. I just wanted to trigger your thoughts with respect to this. So at least please understand there are two kinds of attachments under PMLA. One is the provisional attachment. Provisional attachment can be only for a period of 180 days. Please understand, provisional attachment can be for a period of 180 days. Provisional attachment, it is done by the director enforcement. And there is an adjudicating authority of PMLA. The attachment, the provisional attachment done by the enforcement directorate, by the ED, director enforcement, can be extended by the adjudicating authority up to 365 days. Please understand, one it is 6 months, the other one it is 1 year. The enforcement director enforcement can attach, that provisional attachment can be there only for a period of 180 days. And the adjudicating authority can go up to 365 days. So the provisional attachment, it is referred under section 5, subsections of section 5, provisional attachment under PMLA. Now, can a property which is under the CRP, which is under moratorium under section 14, whether that can be attached by the PMLA is the question that is there before us. We'll address it, but please hold on. The second one, it is the permanent attachment. Permanent attachment, it is coming under section 8 of the PMLA. Section 8 says where the adjudicating authority decides under subsection 2 that the property is involved in money laundering, he shall, by an order in writing, confirm the attachment of the property made under subsection 1 of section 5 or the retention of the property. It can be anything. It can be property, it can be something, it can be gold, it can be money, it can be records, it can be documents, it can be books, etc. That whereupon such attachment or retention or freezing of the seized or frozen property or record shall it can be extended up to 365 days by the adjudicating authority. Mind you, whether it is 365 days or 180 days, whether by the enforcement directorate or by the adjudicating authority, both these attachments are provisional attachments. This is only provisional attachment. This is not a permanent attachment. And permanent attachment can be done only by the special courts. Special courts constituted under the PMLA. where the trial under this act, the PMLA Act, cannot be conducted by reason of the death of etc. etc. These are not relevant for us. The Section 8, subsection 8 of Section 8, where the property stands confiscated to the central government under subsection 5 of Section 5, the special court in such a manner as may be prescribed may also direct the central government to restore such a confiscated property or part thereof of a claimant with a legitimate interest in the property who may have suffered quantifiable loss, etc., as a result of the offense of money laundering. Now, we come to understand that under PMLA, there are two kinds of attachment. One, it is provisional attachment, and the other one, it is permanent attachment. Provisional attachment, it is done by the Enforcement Directorate, ED, and the adjudicating authority. Enforcement Directorate up to 180 days, by the adjudicating authority up to 365 days. And permanent attachment by the special courts. Now, whether these attachments can be done or whether these are possible during the CIRP when the moratorium is in force. We will see some of the case laws before coming to the ultimate case of Kalyani Transco. We will see some of the earlier cases. Now, something that was very interesting in 2022, there was an Ashok Kumar Saravagi case before the Supreme Court with respect to this particular point, whether attachment can be done by the PMLA when the moratorium is in force. But unfortunately, that is withdrawn now. 2022, this question was there, the Supreme Court. It should have been decided earlier, but now it is withdrawn. Saravagi case, it is withdrawn. And these are all some NCLAT and High Court cases. The NCLAT case, Manoj Kumar Agarwal, somebody was referring to this judgment. It is a 2024 January judgment. So this NCLAT and the Appellate Tribunal for Forfeiture of Properties in the case of Bank of India considered the action of attachment to be civil action because it does not decide on the criminality of the offense, nor does it have the power to impose penalty or punishment. The court said the penal aspect of the money laundering offense is tried separately by the special courts. The sum and substance of the matter it is, there are two kinds of attachment, provisional attachment and permanent attachment. Provisional attachment, it is done by either by the ED or by the adjudicating authority. In all these cases, the High Court cases and the NCLT cases, they went on to say that the provisional attachment is a civil action by the PMLA. That cannot be said to be a criminal action. No punishment can be imposed. No punishment can be imposed by the Enforcement Director and by the adjudicating authority. It can be done. The punishment for the criminal activity of money laundering can be done only by the special courts. So when the special court attachment it comes, no, it will be permanent attachment. Provisional attachment is only a civil action. It is only civil proceedings. So as far as the moratorium it is concerned, civil proceedings cannot be done. So if there is provisional attachment during the CRP, when the Section 14 moratorium is in force, this provisional attachment cannot be done by Enforcement Directorate or adjudicating authority. This was a decision with respect to many of the cases. This was the decision. It is only a civil action or it is civil proceedings. Civil proceedings cannot be done during moratorium. So indirectly meaning to say that the action by the special court under the PMLA, it is criminal proceedings. Criminal proceedings, it is outside Section 14 moratorium. So that can be done. So criminal proceedings, action against the criminal proceedings can be done by special courts so that permanent attachment can be there. So this is referred, let us say this is an enclosed judgment with respect to Manoj Kumar Agarwal case. Then there are a lot of cases. Most of the cases, it all went to the direction that provisional attachment cannot be done. Now the question that arises, unless it is provisional attachment, how can they proceed for the permanent attachment? Because it is the proceedings, it is series of actions, it has to be there. No provisional attachment, then there is permanent attachment. So initially it is 180 days, maybe extended up to 360 days by the adjudicating authority or till the continuation of the proceedings, whichever is earlier, they say. And ultimately it can be permanently attached by the special courts. Now, ultimately in September, And this judgment is also very interesting. The property adjudged to be acquired from proceeds of crime, operational debt. Now, why the government is attaching a property, confiscating a property under the PMLA? It is not to recover any money. It is not to recover any money. When there is a person who is into some illegal activity of money laundering, or there is an offense which is a predicated offense, which is a scheduled offense, he has committed that offense. From the offense, he has earned money. They will presume that that money is proceeds of crime. It is used for money laundering activities. So that such person will not be permitted to enjoy the fruits of such proceeds. So that it is attached. It is not to recover any debt or anything that is due to the government. It is not for recovering that. So this particular judgment was referring to, observed that if assets are seized by the enforcement directorate and finally hold that the assets were purchased out of the proceeds of crime, in such a case, the amount as may be generated out of the assets will come within the meaning of operational debt payable to enforcement directorate, for which it may file a claim. It is very funny. See, here it says that let the enforcement directorate file a claim before the RP. But they don't want to recover anything. No, see, they don't have an operational debt. They don't have an operational debt. It is not a government dues. Why they are attaching a property? They are confiscating a property because the person has earned money from illegal activities. Ultimately, they don't want that person to enjoy that. It is not for recovery of any money. But this particular judgment, 2020 judgment, it says that let the government file a claim, the enforcement directorate file a claim as an operational debt, as government dues. No, but we cannot endorse that view. No, see, we cannot go with that view. And they also went to the extent of saying that, let us say, Axis Bank case also saying that no provisional attachment is permissible. Somebody said it is not possible because it is civil proceeding. Here they say that provisional attachment is possible.
So may I ask a question?
Please, please.
So given that the IBC's time-bound creditor protection framework, isn't the ED's practice of attaching core operating assets during CIRP effectively defeating the code? I mean, shouldn't Parliament step in and create a clear statutory priority between IBC and PMLA instead of leaving it to case litigation? Like this is like case to case we are discussing. So
In
what is
fact,
your
my answer to your question, more or less that is issue it is not permanently, but at least temporarily that is solved by issuance of the circular by the IBBI on 4th November. We will discuss that circular. I'm just holding that circular.
So we are having little paucity of time. If we can discuss that circular, I'd request
Yeah,
you
please.
if there's no problem.
I will expedite.
Please, thank you. Thank you, sir.
Then we will discuss the ultimate case law. This is a September 2025 judgment of the Supreme Court. Supreme Court in Kalyani Transco case. We'll deliberate. One of the most crucial issues addressed by the Supreme Court was the role and jurisdiction of the NCLT and NCLAT in overriding enforcement actions initiated by the statutory authorities such as the ED under the PMLA. In the present case, the NCLAT had stayed a provisional attachment order issued by the Enforcement Directorate by an ex parte order on October 14, 2019. Subsequently, Section 32A was inserted in the IBC with effect from 28 December 2019. Liability for the prior offenses, as you all understand. To deal with the issue of liability of a corporate debtor for offenses committed prior to the commencement of CRP. Shortly thereafter, the NCLAT impugned order held that in view of Section 32A of the IBC, the Enforcement Directorate did not have powers to attach assets of the corporate debtor upon approval of the resolution plan, and that the criminal investigations pending against the corporate debtor also would stand abated. However, the Supreme Court in the present case, I'm talking about the Kalyani Transco case, 2025. In fact, the Kalyani Transco, the initial judgment, it was May 2025. There was a review judgment in September, in July 2025, and the final judgment has come in September 2025. 26th September 2025. However, the Supreme Court in the present case overturned the findings of the NCLAT and has conclusively held that neither the NCLT nor NCLAT has jurisdiction to review decisions taken by statutory authorities on matters that are in the realm of public law. Their jurisdiction and powers under the IBC are well circumscribed under Section 31 and 60 for NCLT and 61 for NCLAT, we all know. The Supreme Court, citing its earlier judgment in embassy property developments, clarified that jurisdiction of NCLT NCLAT under Section 60, subsection 5, which we all use regularly, which covers questions arising out of or in relation to insolvency resolution, does not extend to reviewing or interfering with the decisions made by statutory authority in the realm of public law, like the actions under PMLA. It was further held that in the light of statutory scheme as culled out from the various provisions of the code, it is clear that wherever a corporate debtor has to exercise a right that falls outside the purview of IBC, especially in the realm of public law, they cannot take a bypass and go before NCLT for enforcement of such a right. Since NCLT cannot exercise judicial review powers falling outside the IBC or within the public law, the NCLAT as an appellate authority under Section 61 also cannot exercise power or jurisdiction beyond Section 61 of the IBC. Thus, the Supreme Court emphasized that the deciding such an issue in a company appeal under Section 61 was beyond the jurisdiction of NCLAT, and that such interference resulted in judicial overreach and is thus ultra vires the statutory mandate. This was the observations of the Supreme Court with respect to Kalyani Transco case in 2025 judgment. Now, maybe I do understand that. I'm just closing this. This is the circular issued by IBBI on 4th November. I hope it is visible.
Yes, sir, it's visible. Yeah, it's visible, sir.
Undertaking, subject it is undertaking by IPs before the special courts under PMLA. It has been observed that in certain cases under the IBC, the assets of the corporate debtor are under attachment by the Enforcement Directorate under the provisions of the PMLA 2002. The restitution of such attached assets can significantly enhance the value of the corporate debtor, thereby leading to higher realization. Accordingly, it is hereby advised that in cases where assets of the corporate debtor are attached by the ED under the provisions under PMLA, the insolvency professional may, you will raise your eyebrows, but still the insolvency professional may file an application before the special court under Section 8, subsection 7, 8, subsection 8, which you have seen of the PMLA for restitution of such assets. Further, with a view to facilitate the expeditious disposal of such applications by the special courts, the Insolvency and Bankruptcy Board of India, in consultation with ED, has formulated a standard undertaking to be furnished by the IP along with the application for restitution of assets. The said undertaking is annexed here too with the circular. This is the undertaking to be submitted by the RP while filing an application under Section 8.7 of PMLA or 8.8 of PMLA. I so-and-so IP having a registration number in my capacity as a resolution professional or liquidator hereby undertake that during the corporate insolvency resolution process or liquidation process of the said corporate debtor, usage of restituted assets applicable only in cases where the promoter is ineligible under Section 29A of the Insolvency and Bankruptcy Code 2016. The restituted assets shall not be sold, transferred, or otherwise disposed of directly or indirectly to any person covered under Section 32A2 so-and-so, so-and-so. The restituted assets shall not be utilized directly or indirectly in any manner that benefits any person or entity named as an accused in charge sheet number, ECIR, etc., enforcement case information report by the Enforcement Directorate or any relevant predicate agency, etc. Periodic reporting, that is more very, very interesting. From the date of restitution until the approval of the resolution plan or dissolution order by the adjudicating authority, I shall submit quarterly status reports to this special court containing the following details: the status of the restituted assets, details of their usage or monetization, list of beneficiaries of any distribution, inform on any sale or transfer of restituted property. Disclosures in insolvency process. I have disclosed in the IM, information memorandum or action notice, the details of all the properties under ED attachment as on date of this submission. If any further details become available subsequently, I shall disclose the same in updated versions of the IM or subsequent action notices. Cooperation with the ED. I will extend full cooperation to the ED during the investigation, including providing details of UFA transactions, providing details of the committee of creditors, including its constitution and percentage of voting, provide details of successful resolution applicant or successful bidder, including copy of the application, relevant orders or proceedings of the NCLT, document production. I further undertake to provide to the ED and when requested any document and information subject to the following. Documents that are not commercially sensitive in nature shall be furnished immediately on request. Documents that are commercially sensitive in nature, example, valuation report, resolution plans, etc., shall be furnished only after the ED acknowledges such a sensitivity in writing. See, normally we use the word subject to signing a non-disclosure agreement. So, no, subject to signing a secrecy agreement. Here the wording that is used, it is subject to ED acknowledges such a sensitivity in writing. You cannot insist ED to sign an NDA, non-disclosure agreement. Duration of undertaking. The obligations under this undertaking shall remain in effective until approval of the resolution plan or dissolution order. See, IBBI has made the insolvency professionals the victim of another compliance. So this is the circular. This is an outcome of the Kalyani Transco case. Kalyani Transco case. When it has gone out of our hands, they have issued a circular. But again, the RP or the liquidator, the insolvency professionals are going to be the victims. And I can tell you with my limited experience, the breed of people, the enforcement directorate, the breed of people, it is not the kind of people which we face on regular basis. Maybe the other regulatory authorities like income tax or GST or customs, we are used to that. Since I have maybe limited number of cases, I have appeared before the enforcement directorate. The breed of people, the kind of treatment that met out to the people, even to the professionals, because in the professionals, they will entertain only with respect to FEMA, with respect to PMLA, they don't prefer professionals because most of the time when they issue a notice, they will insist on personal appearance of the noticee. And with respect to FEMA, they will entertain maybe professionals also because they will say either by yourself or through an authorized representative. And when it is taken to the special courts, anyway, lawyers should be there. Shankar sir is smiling, I understand. Anyway, from special courts onwards, lawyers should be there. So maybe when, maybe here and after, from 4th November onwards, the enforcement directorate has got some controlling power over the IPs. We are subjecting ourselves to enforcement directorate. No, it should have been the other way around. We submit all the details to the IBBA, then IBBA submit to, let us say, the enforcement directorate. No, see, rather than the RPs are made the victims.
I have a challenge, sir, when I was going through this. There is a gap in this circular for the simple reason that it talks about only resolution plan, RPs, and liquidator. And they're also talking about one line, they're talking about when it is successful resolution plan, successful resolution applicant. Can you just drop down a bit? No, sorry, second page, second or third page. One more page, yeah. Hold on, sir, please. Provide details of the successful resolution applicant bar successful bidder as applicable, including a copy of the application and relevant orders, proceedings of the NCLT. My question to you is, a case where resolution plan is over and the assets is under provisional and later on into the permanent or whatever provisional
Permanent attachment.
Provisional attachment is over, 180 days got over, and permanent attachment is in place. successful resolution applicant theoretically has taken the ownership of the company. Does this circular has any reference in such cases? Here it talks about RP. After the resolution application is approved by the Honorable NCLT, there is no question of RP. There is only a monitoring agent or chairman of the monitoring committee. Do you think that this has got relevance in a case where plan is approved? That is my question. This particular circular. Or do you think that erstwhile RP should take an action? Because one line, look at that, point C, providing details of the successful resolution application. So it presumes that this notification is also applicable to a resolution professional who has seen through the resolution approval process. And as of now, the CD is under the control of or assets of the CD is in the control of successful resolution applicant. That is my little, sort of a confusion, which after going through this resolution.
Going by this format of the declaration per se, at the end of it, it says that duration of the undertaking, this is an undertaking that should be given by the insolvency professional.
During the process.
The obligation under this undertaking, which is given by the resolution professional or liquidator, shall remain effective until approval of the resolution plan or dissolution order by the adjudicating authority. Beyond that, no.
So SRA in the Kalyani Transco, JSW is out of this.
Yes, that's what I understand. See, once the plan it is approved by the adjudicating authority, it has got no relevance.
I endorse your view, sir. I endorse your view. Because in this case, this is an after effect of Kalyani Transco.
Definitely.
And of course, JSW will not get benefit out of this. In a couple of cases where I am handling, a lot of assets are with ED. We don't know how to handle. We also actually don't know what all documents have been taken by the ED from the CD.
Before the issuance of this particular notification and the format of the declaration, see, it was a question of interpretation. Whether section 14 is supreme to ED and whether permanent attachment is something of criminal nature, provisional attachment is of civil nature, we could interpret and just prolong it. Now it is concluded. And you will have to report to ED also. In a case where there is attachment, you will have to report to ED also. And tomorrow they can serve you a notice that no, so please provide so and so details.
And look at this. Can you please drop a bit down? It talks about selling. So this particular circular talks about allowing the assets to be sold. Only thing is, it should not be sold to the benefit of the person who has violated the law.
Yes.
You can give
There's
them
got some reference to 32A because 32A it talks about the persons to whom, let us say, the ineligible persons. No, it is 32A. It talks about no prior offenses. With respect to prior offenses, if the previous management is not involved in the person who takes over the company, if that is not the previous management or any person related to the previous management, then they have 32A protection.
Correct.
Here it says that if those people, the previous management, previous directors, previous stakeholders, etc., are there, benefit will not be, no benefit should be given to those people. 32A is referred here also.
Sir, I'm sorry to interject, sir. We are running beyond our mandated time of 6 o'clock. It is indeed a wonderful discussion. I believe that Namrata will agree with me that we should have a separate full 2-hour session for PMLA with Mr. Joy and Shankar Parikar sir as speakers on this particular topic. So please, Namrata.
Yes, sir. Thank you, Parag, sir, so much. And thank you, Joy, sir, for giving us the entire transition from PMLA to IBC and also getting us into this latest 4th of November circular that has come in. Briefly going through, and I agree with Parag, sir. I think we should have a joint session of Panikar, sir, and you. So it'll be more interesting with the interplay, more specifically the interplay coming into the foray. So with this, I would like to thank Joy, sir, and I would ask Babita to please take over for the closing remarks.
Okay, let me conclude by saying one sentence. No, what Shankar sir asked me, it is the restituted assets should not be given to the people, those who are referred under 32A.
Right, sir.
Right.
Before moving forward, please allow me to present a memento to PT Joy, sir.
Yes, sir.
Unmute
I-
is not there. And just give me a moment, please. So this
So, thank you.
certificate
Thank you. Thank you very much. It's my pleasure. I enjoyed
is
it.
all ours, and we'll send you physical copy of this memento also, sir. And in absentia, this certificate also goes to Harmeet ma'am. Although I have WhatsApp her,
Namrata ji.
Harmeet she's not here, and physically it will be delivered to her.
So thank you very much. I enjoyed in speaking to you. I believe that you enjoyed in listening to me also. In fact, I thought no, I could
Yes,
see
yes,
Mahira sir, but
So it was a wonderful deliberation, sir.
Don't worry, sir. We'll give you, we are not going to leave you. Don't worry.
Babita ji, please.
I invite members of IPNet West to make announcement for the next webinar of IPNet to be held on 15th November.
So
Anybody
Yeah.
available from IPNet West?
yeah, Babita ji, let me-
Good evening, ma'am. Good evening, everyone. I am Suhasini Ashokbi from IPNet South. So we are hosting the next IPNet webinar on November 15th. The topic would be shared shortly in all the WhatsApp groups. So kindly do attend the webinar next week.
Thank you, sir. So, Babita ji, allow me to extend shortest vote of thanks in the
Sir,
history of
please, sir.
IPNet.
Please.
So, instead of going through all the formalities, let me extend my sincere gratitude to everyone who participated today. Your presence, enthusiasm, and active engagement have made this event truly remarkable. Together, we are building a community that will not only foster professional growth, but also drive innovation and collaboration in insolvency professionals across India. Thanks once again to one and all who contributed, participated, and supported this remarkable initiative. Looking forward to have many more knowledge sharing webinars by IPNet. Thank you, everyone.
Thank you,
Thank you,
sir.
sir.
Thank you.